Hello everyone, my name is AJ Buchanan. I work for Northern Kentucky University in the College of Business as the Project and Events Manager. My background is mostly in fundraising for special events, and I'm in the Arts Administration program currently to further my knowledge of development work. So my career goal is to work as a development director for a nonprofit that focuses on community relations. With that said, a contemporary legal issue that I found interesting and important for all nonprofit organizations is one on the discussion of donor disclosure requirements. So Citizens United, which is an organization dedicated to restoring the government to citizens' control, has challenged New York's requirement that charities disclose their major donors as part of registration requirements to solicit contributions in the state. Although Citizens United has submitted disclosures each and every year since they've been established in 1995, the organization has omitted the identification of major donors on its IRS Form 990. Because of this, New York Attorney General's Office has served a deficiency notice to them in 2013, and informing them that they have had a failure to comply with annual disclosure requirements. So, of course, they reacted to that, and this case first went to court in July of 2015, where the U.S. District Court for the Southern District of New York denied Citizens United's request for a preliminary injunction that would prohibit the Attorney General's office from requiring nonprofits to provide information on major donors. And of course, they weren't willing to back down then. So again, in August 2017, they went back to court, and the United States Courts of Appeal for the Second Circuit decided to uphold the dismissal. So the most recent one that's gone to court, there is a 37-page ruling, which I have included on this post as well, in case you are interested in looking through it. But on it, there is a 3-judge panel, and they rejected the arguments submitted by Citizens United, and many of these arguments claimed free speech, prior restraint, and due process. A quote from the judges that I thought was really good was that, although they thought it was plausible for some donors to find it intolerable for law enforcement officials to know where they had made donations, they found no reason to believe that this risk of speech chilling was any more significant than any other kind of disclosure regulations provided by the state. And then another good quote too, Attorney General Eric Schneiderman said that state law demands that organizations like Citizens United disclose their biggest donors to regulators so that they can police fraud and abuse in the nonprofit sector. But again, Citizens United is not quite ready to go down yet still. Michael Booz, who's the vice president and general counsel for the organization, has stated that an appeal to the U.S. Supreme Court may be in the works. So I'm not sure about you, but I found this really interesting because I do believe in privacy of non-profit donors. But I can see the court's argument that this needs to be done because there is so much fraud that is already submitted on Form 990s. And I do believe with their statement that that is information that needs to be known to prevent that. Thank you.